Namaste. This is Advocate Surya Kundeti. Today's topic is special suits. Before we get into this topic in detail, I would like to, as I'm telling this right from in all my classes which are free of cost, are dedicated towards an charitable organization which is involved in developing the nutrient values in children and also for their education. The name of the charitable organization is ABC Trust. And if you are very much in liking of my classes, and I would like to request you, please make a small contributory donation to the charitable trust of 59 rupees through the UPI number, which is 9949398998. At the end of this class, there will be a display of the QR code, which is a UPI code for the transactions, which is related to the ABC Trust, which will be easy for you to scan the QR code and make the contributory charitable donation for 59 rupees. This is only a request. And the most important point is your subscription towards the channel. So the more the subscribers I receive to my channel, the more the encouragement I'm going to have to make more classes related to law and the current affairs that are happening day-to-day activities. So please subscribe to my channel, because your subscriptions are my blessings and my encouragement as well from you. So now let's get into the topic, which is special suits. What is a special suit? In general, for the purpose of procedure, suits may be divided into two classes, namely suits in general classes and suits in special classes. So we have already discussed in the preceding chapter the procedure required to be followed in the former class of suit, which is sections 79 to 93 and orders 27 to 37, deal with suits in special or particular cases and the procedure to be followed in such suits. Suits in special cases, suits by or against government or public officers. So section 79 to 82, order 72. So these are the sections and the orders which are relevant to special. In general, section 79 to 82 and order 27 of the code laid down the procedure where suits are brought by or against the government or public officers. The provisions, however, prescribe a procedure and machinery and do not deal with rights and liabilities enforceable by or against the government. Substantive rights are to be determined in accordance with the provisions of the Constitution. Statutory offer notice, section 80, subsection 1. In ordinary suits, that is suits between individuals and individuals, notice need not be given to the defendant by the plaintiff before filing a suit. Section 80 of the code, however, declares that no suit shall be instituted against the government or against a public officer in respect of any act purporting to do borne by such public officer in his official capacity until the expiration of 2 months next after notice in writing has been delivered to or left the office of. So this is very, very important that every public officer should be served a notice under section 80 of the Code of Civil Procedure if there is a necessity to initiate a legal proceedings against the public officers or government officers which is of public importance and as per the code of the respective procedures. In the case of a suit against the central government, except where it related to railway secretary to the government. In the case of a suit against the central government, where it relates to a railway, the general manager of that railway station or a railway zone. In the case of a suit against the government of a state of Jammu and Kashmir, the chief secretary to that government or any other office authorized by the government in that behalf. So, in all the cases mentioned right now, section 80 is very, very important. In the case of a suit against the government of the state of Jammu and Kashmir, the chief secretary to that government or any other officer authorized by that government in that behalf. In the case of a suit against any other state government, a secretary to that government of the collector of the district, and in the case of a public officer, such public officer. So, the above mentioned rules and regulations and officers are to be strictly followed in serving section 80 notice. Nature and scope. Section 80 of the code enacts a rule of procedure and mandates that no suit shall be instituted against the government or against the public officer until a statutory notice required by section is served. Yes, this is a very, very important point because section 80 is very, very important, and without serving section 80 notice to a public officer or to its related superiors, the suit should not be initiated. So, section 80 lies a very fundamentally strong point in calling a public officer to the courts. Once this notice has been served, we have to wait for a minimum mandated period of 60 days for this initiation of suit based on the notice sent. The section enumerates two types of cases: suits against the government and suits against public officers in respect of acts done or purporting to be done by such public officers in their official capacity. So, object of the notice, the main object of the notice is, under underlying section, is to afford an opportunity to the government of public officer to consider the legal position and to settle the claim put forward by the prospective plaintiff if the same appears to be just and proper. Law Commission's view on this section. The Law Commission did not favor in retaining the provision of issuing a notice and section before filing a suit by the aggrieved party. Before more than 50 years, it noted that this section has worked hardship in a large number of cases where immediate relief was needed. The evidence disclosed that in large majority of cases, the government or the public officer made to abuse of opportunity afforded by the section. In most cases, the notice remained unanswered. But whereas now it is very fast and very effective as well. So what are the essential contents that has to be in the notice under section 80 to any public officer? The notice under section 80 must contain name, description and place of residence of the person giving notice, the statement of the cause of actions, relief claimed by him in considering whether the essential requirements of the section have been complied with. The court should ask the following questions: whether the name, description and residence of the plaintiff are given so as to enable the authorities to identify the person giving the notice, whether the cause of action and the relief which the plaintiff claims have been set out with sufficient particulars, whether such notice is in writing has been delivered to or left at the office of the appropriate authority mentioned in the section, and whether the suit has been instituted after the expiration of 2 months after notice has been served and the plaint contains a statement that such a notice has been so delivered or left. Notice whether empty formality. Statutory notice is not an empty formality. The object is to afford an opportunity to the government or a public officer to reconsider the matter in the light of the settled legal position and take an appropriate decision in accordance with the law. Notice whether mandatory. The provisions of section 80 are express, explicit and mandatory and admit no implications or exceptions. They are imperative in nature and must be strictly complied with. Notice under section 80 is a first step in the litigation. Construction of notice. The provisions of section 80 of the code must be strictly complied with, but it cannot be overlooked that it is a procedural provision, a machinery by which courts impart justice. A notice under this section therefore should not be construed in a pedantic manner diverse from the common sense. A statutory notice must be reasonably construed, keeping in mind the ultimate object of an interpretation should not lead in injustice. Act purporting to be done in official capacity. The expression any act purporting to be done by such public officer in his official capacity takes within its sweep acts as also legal omissions. Likewise, it also covers past as well as future acts. Waiver of notice. Though issuance of notice under section 80 is mandatory and a condition precedent for the institution of the suit, the provisions is merely procedural in nature and not a substantive one. It does not affect the jurisdiction of the court when section 80 notice is not served. But serving a section 80 notice improves your credibility in the suit. So always give a section 80 notice if you are filing a suit against a public officer. Form of notice. A notice under section 80 need not be in a particular form as no form has been prescribed by the code of the purpose. It is sufficient if the notice complied with the requirement of this section. It should contain details sufficient to inform the party of the nature and basis of the claim and the relief sought. Mode of service. The notice under section 80 of the code should be delivered to or left at the office of the appropriate authority specified in the section. It should be given to the Secretary of the Department of the Government, of the Collector of the District as well. Technical defect in notice, section 80 subsection 3 and subsection 9(3) to section 80 as inserted by the Code of Civil Procedure Amendment Act 1976 clarifies that no suit instituted against a government or public officer shall be dismissed merely on ground of error of defect in the notice. If in such notice, the name, description and residence of the plaintiff has been given as to enable the authority or public officer to identify the person serving the notice and such notice has been delivered or left at the office of the authority or public officer and the cause of action and the relief claimed by the plaintiff had been substantially indicated therein. It means that if all the above conditions are fulfilled, Section 80, even though it does not have the procedure as per Section 80, the notice is valid. It cannot be dismissed. Exclusion of period of notice. In computing the period of limitation of instituting a suit against the government or public officer, the period of notice has been excluded. Leave of court. Urgent relief, Section 80, subsection 2. Subsection 2 of Section 80 as inserted by the Code of Civil Procedure Code Amendment Act 1976 enables the plaintiff to institute a suit against the government or public officer for obtaining urgent or immediate relief with a leave of the court even without serving notice to the government or public officer. The subsection thus engrafts an exception to the rule laid down in the subsection 1 of Section 80 and allows the plaintiff to obtain urgent relief in grave cases even without issuing notices as well. A writ petition. A writ petition under Article 32 or 226 of the Constitution cannot be said to be suit within the meaning of the Section 80 of the code. Hence, giving a prior notice to the government or public officer is not necessary before filing a petition in the Supreme Court or in a High Court. Computation of limitation. In computation, the period of limitation for filing a suit, the period of notice should be excluded. Premature suit. The suit instituted before the expiry of 2 months of notice as required by Section 80 of the code is liable to be dismissed only on that ground. Appeal. An order passed under Section 80 is neither a decree not an appealable order, and hence no appeal lies against such order. Revision. An order under Section 80 of the code is a case decided on Section 115 of the code and it therefore revisable. Title of the suit. Section 79. In a suit by or against the government, the authority to be named as plaintiff or defendant as the case may be shall be. In such case of a suit by or against the central government, the Union of India, and in the case of suit by or against the state government and the state. Statement in the plaint. The plaint can be presented after the expiration of 2 months of notice, which must contain a statement that a statutory notice under Section 80 of the code has been delivered or left as required by subsection 1 of the said section. An omission to make such a statement is fatal, and its absence, the plaint will be rejected by the courts. Parties. Where a suit is filed against a public officer in respect of an act, any act purporting to be done by him in his official capacity, the government shall be joined as a party to the suit. Procedure, which is Order 27. In a suit by or against the government, the plaint or written statement shall be signed by any person appointed by the government who is acquainted with the facts of the case. Other privileges. Rules 5A provides that when a suit is filed against a public officer in respect of any act alleged to have been done by him in his official capacity, the government should be joined as a party to the suit. Rule 5B casts a duty on the court in suits against the government or public officers to assist in arriving to a settlement. Rule 7 provides for extension of time to enable a public officer to make a reference to the government wherein he is a defendant. In most of the cases, if a suit has been filed against a public officer, the public officer should be held liable for his misconduct and suspension should be ordered. Suits by aliens. Section 83. Alien enemies residing in India with the permission of central government and alien friends may sue in any court otherwise competent to try a suit as they were citizens of India. Alien enemies residing in India without such permission or residing in a foreign country cannot sue in any courts. Every person residing in a country which is at war with India shall be deemed to be an Indian enemy. Suits by or against foreign rules, ambassadors or envoys, sections 84 and section 87A. A foreign state may sue in any competent court provided that such suit is for the enforcement of private right vested in the ruler of that state or in any officer or such state in his public capacity. Foreign state means any state outside India which has been recognized by the central government. And suits by or against rulers of former Indian states, section 87B. In the case of any suit by or against the ruler of any former Indian state which is based wholly or partly upon a cause of action which arose before the commencement of the constitution of the same can be filed in accordance with the provisions in relation to suits by or against foreign rulers, ambassadors and envoys. Suits by or against soldiers, sailors and airmen, which is Order 28, where any soldier, sailor or airman is a party to the suit who is in actual service and is unable to obtain leave for prosecution or descending the suit in personam, he may authorize any person to sue or defend him. The person so authorized may himself prosecute or defend the suit or appoint a pleader. Summons on a soldier, sailor or airman may be served through his commanding officer. Suits by or against corporations, Order 29. A corporation is a fictitious or imaginary person invested by law with the attribute of a person. It can sue and be sued in its corporate name as well. Suits by or against partnership firms, which is Order 30. Suits by or against partners is Rule 1 under Order 30. Two or more persons claiming or being liable as partners and carrying on business in India may sue or be sued in the name of the firm of which they were partners when the cause of action occurred. Any party to a suit may in such case apply to the court of the accrual of the cause of action, partners in such a firm. In suit by or against a firm, any pleading may be signed and verified by any one of the partners. So, service of summons, which is Rules 3 to 5. Rule 3 provides for service of summons upon the firm and its partners. Rule 4 declares that if any of the partners dies before filing or during the pendency of the suit, it is not necessary to join his legal representative as a party to the suit. Appearance by partners, Rule 6 to 8. The defendant partners shall appear individually in their own names. All subsequent proceedings, however, shall continue in the name of the firm. If a notice is served on a person having control or management over the partnership business, he need not appear unless he is a partner. Suits between co-partners, which is Rule 9. Order 30 applies also to suits between a firm and one or more of its partners therein, and to suits between firms having one or more partners in common. No execution, however, can be issued in such suits except with the leave of the court. Suits against persons carrying on business in names of others, Rule 10. Any person carrying on business in a name and style of other than his own name, or a Hindu undivided family carrying on business under any name may be sued in such name or style, or if it were a firm name, and insofar as the nature of such case permits, all rules under Order 30 shall apply accordingly. Decree in partnership suits. Order 20, Rule 15 of the Code provides for passing of the preliminary decree by the court before passing a final decree in a suit for dissolution of partnership of taking of partnership accounts. Execution of decree against partnership firm. Order 21, Rule 49 and 50 provide for execution of a decree against a partnership firm and for attachment of partnership property. So, suits by or against trustees, executors and administrators, Order 31. In suits between strangers and person beneficially interested in the property vested in trustees, executors or administrators, it is not necessary to join the beneficiaries as parties to the suit. So, suits by or against minors and lunatics, Order 32. Minor is a definition by Rule 1. A minor is a person who has not attained the age of 18 years, but in the case of a minor of whose person or property a guardian or next friend has been appointed by a court, or whose property is under the superintendence of a court of wards, the age of majority is 21 years. Nature and scope. Order 32 prescribes the procedure of suits to which minors or persons of unsound mind are parties. Object. Order 32 had been specially enacted to protect the interests of minors and persons of unsound mind and to ensure that they are represented in suits or proceedings by persons who are qualified to act as such. Suits by minors, Rule 1 and 2A. Every suit by a minor should be instituted in his name through his guardian or next of a friend. If it is not done, the plaintiff will be take off the file which such minor is a plaintiff. The court may at any stage of the suit order his guardian or next friend, either on the application of the defendant or suo motu for reasons to be recorded, to furnish security for costs of the defendant. So, suits against minors, Rule 3. Where a suit is instituted against a minor, the court should appoint a guardian ad litem to defend the suit. Such appointment should continue throughout all the proceedings, including an appeal or revision and an execution of a decree, unless it is terminated by retirement, removal or death of such guardian. Who may be appointed as guardian or next friend? Rule 4. Any person who has attained majority and is of sound mind may act as a guardian or next friend, provided his interest is not adverse to that of a minor who is not the opposite party in the suit and who gives consent in writing to act as a guardian or next friend. Powers and duties of a guardian or next friend, rules 5 to 7. No guardian or a next friend can, without the leave of the court, receive any amount or movable property on behalf of a minor by way of compromise, nor enter into an agreement or compromise on his behalf in the suit. An application for the leave of the court should be accompanied by an affidavit of the next friend or guardian, and if the minor is represented by a pleader with the certificate of the pleader that such compromise in his opinion for the benefit of the minor. Interests of infants of paramount consideration. What is this? The provisions of the code have been based on the general principles that interest of infants is a paramount consideration. It is therefore the duty of the court to ensure that guardians and next friends act honestly and exercise their discretionary powers bona fide in the interests of minors. Retirement, removal or death of a guardian or next friends, which is rules 8 to 11. A next friend or guardian of minor cannot retire without first procuring of a fit person for substituting him and giving security for the costs already incurred by decree against minors. Rule 3A. The decree passed against a minor without appointment of next friend or guardian is null and void, but a decree passed against a minor cannot be said to be illegal, nor can be set aside only on the ground that the next friend or the guardian of the minor had an interest in the subject matter of the suit adverse to that of the minor. Minor attaining majority, rules 12 to 14. On attaining the age of majority, a minor plaintiff may adopt any of the following courses. What is the first one? He may proceed with the suit by discharging his guardian friend, or he may abandon the suit and apply for its dismissal or repayment of cost to the defendant or to his guardian or next friend. He may apply for dismissal of the suit on the ground that it was unreasonable or improper. Where he is a co-plaintiff, he may repudiate the suit and may apply to have his name struck off as co-plaintiff. Persons of unsound mind. The provisions of Order 32 also apply to lunatics and persons of unsound mind. Suits concerning family matters, which is Order 32A, as inserted by the Code of Civil Procedure Amendment Act 1976, lays down the procedure where suits or proceedings relate to matters concerning a family. Ordinary judicial procedure is not ideally suited to be sensitive area of a personal relationship. Litigations concerning affairs of the family require special approach, keeping in mind serious emotional aspects involved. Family counseling as one of the methods of achieving the ultimate object of preservation of the family, hence should be kept in the forefront. Friendly suits, section 90, order 36, nature and scope. A friendly suit is a suit where the parties do not approach a court by presentation of a plaint as is done in ordinary civil litigation. They are, however, interested in the decision of any question of fact or a law. For the said purpose, they enter into an agreement in writing stating such questions in the form of a case for the purpose of obtaining the opinion of the court. And object. In the statement of objects and reasons, it was stated that where parties agree to state a case for the opinion of the court would try and determine such a question by registering it as a suit. Upon the judgment so pronounced, a decree will follow. Such decree would be a compromise decree. And conditions. The following conditions must be satisfied before a court will hear a friendly suit. The agreement is duly executed by the parties. The parties have a bona fide interest in the question stated and the case is fit to be decided. What is the procedure? Order 32 provides a procedure to be followed in friendly suits. Rules 1 and 2 speak of form and contents of agreement. Such agreement duly entered into between the parties should be filed in the court having jurisdictions to entertain the suit. It shall be registered as a suit and shall be heard and disposed of any judgment which will be followed by a decree. Thus, virtually, the decree is a concerned decree. No appeal lies for such a decree. And a decree passed in a friendly suits is the nature of a compromise decree. It is therefore not appealable. And interpleader suit, section 88, order 35, meaning To interplead means to litigate with each other to settle a point concerning a third party. In Halsbury laws of England, it has been stated. Halsbury laws are the fundamental or the foundation laws of Code of Civil Procedure 1908. The expertise or the fundamental knowledge acquired by Halsbury laws will be an eminent strength to understand the Code of Civil Procedure 1908. So, where a person is under liability in respect of a debt or in respect of any money, goods or chattels, and he is or expects to be sued for or in respect of the debt or money or those goods or chattels, two or more persons making adverse claims thereto, he may apply to the court for relief by way of interpleader. So what is the nature and scope of this interpleader? An interpleader suit is suit in which the real dispute is not between a plaintiff and a defendant, but between a defendants who interplead against each other. Unlike in ordinary suit, in majority of cases, there is a dispute between a plaintiff and defendant. In any interplead suit, the plaintiff is not really interested in the subject matter of the suit. And what is the object of his interpleader? The primary object for filing an interpleader suit is to get claims of rival defendants adjudicated. It is a process wherein the plaintiff calls upon the rival claimants to appear before the court and get their respective claims decided. What are the conditions? Section 88 are related to the conditions for interpleader. Before an interpleader suit can be instituted, the following conditions must be satisfied. So what are those conditions? There must be some debt, sum of money or other property, movable or immovable, in dispute. Two or more persons must be claiming it adversely to one another. The person from whom such debt, money or property is claimed must not be claiming interest therein other than the charges and costs, and he may be ready and willing to pay or deliver it to the rightful claimant, and there must be no suit pending wherein the rights of rival claimants can be properly adjudicated. So what are some of the illustrations that can be drawn for the above points? A is in possession of property claimed by B and C adversely. A does not claim any interest in the property and is ready to deliver it to the rightful owner. A can institute an interpleader suit. Who may file interpleader suit? A person who has no interest in any debt, sum of money or other property, movable or immovable, except the charges or costs, and is ready to pay or deliver the property to the rightful claimant, may file an interpleader suit. Who cannot file interpleader suits, which is Rule 5, which is said in Rule 5. An agent cannot sue his principal or a tenant or his landlord for the purpose of compelling them to be interpleaded with persons other than persons claiming through such principals or landlords. So what is a test in this one? In order to decide whether the suit is in the nature of an interpleader suit, the court must have regard to all the priors in the plaint. A suit does not become an interpleader suit merely because the plaintiff requires the defendants to interplead with each other as regards one of the priors in the plaint. So what is the procedure? Order 35 Rules 1 to 4 define the procedure for interpleader. Order 35 lays down the procedure for interpleader suits. In every interpleader suit, in addition to other statements, the plaint also must state that the plaintiff claims no interest in the subject matter in dispute other than the charges and costs. The claims have been made by the defendants severally, and there is no collusion between the plaintiff and any of the defendants. So how will the appeal be in this interpleader? An order dismissing the interpleader suit filed by the plaintiff is a decree. Likewise, an adjudication upon the claims of defendants is also appealable a decree. So a decision under Rules 3, 4 and 6 of Order 35 is an appealable order. So what is this? And these are all the conditions that are involved in the interpleader suits. So now we have suits by indigent persons according to Order 33. Nature and scope. Order 33 provides for filing of suits by indigent persons. It enables persons who are too poor to pay court fees and allows them to institute suits without payment of requisite court fees. Indigent persons means who are unable to pay the court fees. So what is the object? The provisions of Order 33 are intended to enable indigent persons to institute and prosecute suits without payment of any court fees. It serves a triple purpose. First one is to protect bona fide claims of an indigent person, to safeguard interests of revenue and to protect defendant from harassment. Indigent person, meaning Order 33, Rule 1. A person is an indigent person if he is not possessed of sufficient means to enable him to pay the fee prescribed by law for the plaintiff in such suit, where no such fee is prescribed, where he is not entitled to property worth 1,000 rupees. Sufficient means, meaning the expression sufficient means contemplates ability or capacity of a person in ordinary course to raise money by available lawful means to pay court fees. Contents of application Rule 2. Every application for permission to sue as an indigent person should contain the following particulars. The particulars requested in regard to plaintiffs in suits, a schedule of any movable or immovable property belonging to the applicant with the estimated value thereof, and signature and verification as provided in Order 6, Rules 14 and 15. Rejection of application, which is Rule 5. The court will reject an application for permission to sue as an indigent person in the following cases: where the application is not framed and presented in the prescribed manner, where the applicant is not an indigent person, where the applicant has within 2 months before the presentation of the application disposed of any property fraudulent or in order to get permission to sue as an indigent person, where there is no cause of action. So in these cases, it is not possible for a person to be declared as an indigent person. Enquiry, which is Rule 1A. In the first instance, an enquiry into the means of applicant should be made by the Chief Ministerial Officer of the court. The court may adopt the report submitted by such officer or may itself make an enquiry. Where permission is granted, Rule 8 to 9A, where an application to sue as an indigent person is granted, it shall be deemed to be a plaintiff in the suit and shall proceed in the ordinary manner. Where permission is rejected, which is Rules 15 and 15A, where the court rejects an application to sue as an indigent person, it will grant time to the applicant to pay the court fees. Revocation of permission, Rule 9. The court may, on an application by the defendant or by the government pleader, revoke permission granted to the plaintiff to sue as an indigent person in the following cases: where he is guilty of vexatious or improper conduct in the course of the suit, or where his means are such that he ought not to continue to sue as an indigent person. So this is integrity. Costs. The cost of an application to sue an indigent person shall be costs in the suit. Recovery of court fees and costs. Where indigent person succeeds, the cost will be recovered from the defendant. Where indigent person fails, the court will ask pay the court fees and the costs as well. Rights of a state government. The state government has right to recover court fees. For that purpose, it is deemed to be a party to the suit. Realization of court fees, Rule 14. Where an indigent person succeeds in a suit, the state government can recover court fee from the party as per the direction in the decree, and it will be the first charge on the subject matter of the suit. Set off or counterclaim. An indigent person may also plead set off or file counterclaim without paying court fees. Appeal. An order rejecting an application to sue as an indigent person is appealable. Appeals by indigent person, Order 14. A person unable to pay court fees on memorandum of appeal may apply to allow him to appeal as an indigent person. Enquiry to be initiated before granting the prayer. So, suits relating to constitutional validity of statutory instruments, Order 27A. What is this? Order 27A provides that in a suit or appeal in which a substantial question of law or to the interpretation of the Constitution as referred to in Article 31 subsection 1 or 147 of the Constitution of India is involved, the court shall not proceed to determine the question until after notice to Attorney General in India is a question of law concerns the central government, and to the Advocate General of the state if the question of law concerns the state government. So this is a procedure to be adopted in Order 27A. So what is the next point we have in this context? Mortgage suits. Order 34. Nature and scope. Order 34 lays down procedure with regard to suits relating to mortgage of immovable property. It provides for the frame of the suit relating to sale foreclosure and redemption of mortgage property, and also to enforce charges. Mortgage. What is exact the meaning of mortgage according to law? Mortgage is defined in the following words. It's a transfer of interest in specific immovable property for the purpose of securing the payment of money advanced or to be advanced by way of loan on existing of the payment of money advanced or to be advanced by way of loan and existing of future debt or performance of an engagement which may give rise to a pecuniary liability. So what are the essentials of this mortgage? It becomes clear that there are always two parties to a mortgage transaction, mortgager and mortgagee. What is the object? Provisions are mentioned in Order 34 prevails. Parties. Rule 1 of Order 32 enacts that all persons having an interest either in the mortgage security or in the right of redemption shall be joined as parties to any such suit relating to mortgage. Suit for foreclosure, rules 2 to 3. Preliminary decree. In suit for foreclosure, if the plaintiff succeeds, the court shall pass a preliminary decree. Final decree, where the defendant makes a payment of all amounts on or before the date fixed or extended by the court. For such payment, the court shall pass a final decree on receipt of application from him. Suit for sale, rule 4 to 6. Preliminary decree, if plaintiff succeeds, the court shall pass a preliminary decree. Final decree, before sale, if the defendant makes all payments, an application, the court shall make final decree on behalf of the defendant. Suits for redemption, rules 7 to 9. Preliminary decree, plaintiff gets a preliminary decree upon payment of all the fees. Final decree is basing on the payments by the plaintiff. Final decree will be issued favoring plaintiff. So, what are the summary suits according to Order 37? Nature and the scope of the summary suits. Order 37 provides summary procedure in suits based on negotiable instruments of where the plaintiff seeks to recover a debt or a liquidated amount. The provisions of Order 37 are constitutional. So, what is the object of this? It is to ensure an expedition, hearing and disposal of the suit and to prevent unreasonable obstruction by the defendant who has no defense and to assist expeditious disposals of the cases. So, what is the discretionary power? The discretionary power conferred upon the court under Order 37 should be exercised judicially. Judiciously and on well-settled principles of natural justice, where defense raises a triable issue, leave should be granted unconditionally. It is not done, leave may become illusory. What is the extent and applicability? The provisions of Order 37 apply to high courts, city civil courts, courts of small causes and other superior courts as well. So what is the procedure involved in this? Rules 2 and 3 provide for procedure of summary suits. Rule 2 provides that after the summons of the suit has been issued to the defendant must appear and the plaintiff will serve a summon for judgment on the defendant. The defendant is not entitled to defend a summary suit unless he enter an appearance. Test. The test whether leave to defend should be granted or not is to see whether the defense raises a real, honest and bona fide dispute and raises a triable issue or not. If the court is satisfied that the defense has raised a triable issue or a fair dispute has raised, leave to defend should not be refused. Special circumstances, what does it mean? The expression special circumstances is not defined in the Code of Civil Procedure. It is ordinary dictionary meaning. It connotes something exceptional in character, extraordinary something exceptional in character, extraordinary significant and uncommon. So difference between summary suit and ordinary suit. Whereas in ordinary suit, the defendant is entitled to defend the suits as of right. In a summary suit, he is not so entitled except he leave of the court. Recording of reasons. Generally, a court while granting conditions, leave should record reasons. Absence to record reasons, however, will not make the order invalid. Appeal. No appeal lies against an order granting or refusing leave to defend under Rule 3, but where a decree is passed in a summary suit, an appeal lies. Revision. An order passed under Order 37 is a case decided under Section 115 of the Code of Civil Procedure 1908 is revisable through a High Court Generally, it does not interfere with the discretion exercised by the trial court. This was already detailed in my earlier classes also. So, writ. In appropriate cases, a High Court may interfere with an order passed granting or refusing leave under Rule 3. Principles. The High Court of Calcutta laid the following principles in Kiranmoyi Dasi versus J. Chatterjee. This is a very famous case. If the defendant satisfies the court that he has a good defense to claim on its merits, the plaintiff is not entitled to leave the signed judgment and the defendant is entitled to unconditional leave to defend. If the defendant has no defense or the defense is set up is illusionary or sham or particularly moonshine, then ordinarily the plaintiff is entitled to leave to sign judgment and the defendant is not entitled to leave to defend. So this is like this. We have many more conditions. I would deeply recommend that you please refer to the appropriate profound books in the Civil Procedure Code to find out this kind of conditions where defense can be obtained by the defendants even after decree has been mentioned. Suits relating to public nuisance, Section 91. Nature and scope. Section 91 of the Code provides for filing of a suit in the case of public nuisance or other wrongful acts affecting the public at large. It states that such a suit can be instituted for declaration, injunction, or such other relief which may be appropriate in the circumstances of the case. What is the object of this? A very famous publisher, Latanlal Sir and Dheeraj Lal, has stated in their publications, though not so dangerous as an occasion for keeping the peace or good behaviors, nor so urgent as unlawful assemblies, they are yet sufficiently fraught with potential danger as to warrant a summary action on the part of the magistrate. Public nuisance, what does it mean? This is a very vast subject in this Code of Civil Procedure, which has to be said in a couple of classes, which I will try to do it in the future classes. So public nuisance, what is the meaning of this? The expression public nuisance has not been defined in the code. It can, however, be said to be an act or omission which causes common injury, danger or annoyance to the public or to the people in general who dwell or occupy property in the vicinity of which must necessarily cause injury, obstruction, danger or annoyance to the persons who may have occasions to use public rights. Who may sue? Advocate General. Two or more persons with the leave of the court. Any private person if he has a sustained special damage. And what are the remedies sought in the nuisance cases? A person committing a public nuisance may be punished under the IPC severely, aggressively as well. Magistrates may remove public nuisance in certain circumstances by exercising summary powers. A suit can be instituted for declaration, injunction or other appropriate relief without proper or special damage, and a suit may also be filed by a private individual where he has suffered special damage. What is an appeal? An appeal lies against an order refusing to grant a leave to file a suit for public nuisance or other wrongful acts affecting public. So suits relating to public trust, which is Section 92, the nature and scope of Section 92 of the Code of Civil Procedure Code provides for filing of a suit in respect of a breach of trust created for public purpose or of a charitable or religious nature by the Advocate General or two or more persons having an interest in the trust with the leave of the court for reliefs specified therein. Extent and applicability. A suit under Section 92 of the Code is of special nature for the protection of the public rights in public trusts and charities. Such a suit is basically on behalf of a persons interested in the trust. So what is the main objective of this protection? The main objective of this provision is to afford protection to public trusts and a charitable or religious nature from being subjected to harassment by suits being filed against them, and to prevent multifarious and vexatious suits being filed by irresponsible person against the trustees whose duty is to administer such trusts. However, trusts are not permitted to cause any disturbances or a breach of fundamental rights to its surrounding areas or livelihoods. Conditions. For action, the following conditions to be fulfilled. The trust must have been created for public purpose of a charitable or religious in nature. There must be a breach of trust or direction of the court must be necessary. into the administration of such a trust. Section whether mandatory. Yes, the provisions are mandatory and must be complied with. Where the conditions laid down in the section have not been fulfilled, so no suit can be instituted. Who may sue? Advocate General or two or more persons having an interest in the trust and who have obtained the leave of the court. Who may be sued? The suit may be brought against the person in possession of trust, property who claim adversely to the trust or against trustees who have committed breach of trust. Notice, considering the object underlying section 92 of the code, the court should normally issue a notice to the defendants before granting to the file of suit. What is a relief sought? One or more of the following reliefs: removing by trustees, appointing a new trustee, vesting any property in a trustee, and directing of accounts and inquiries, appeal. An appeal lies against an order. Doctrine of Cyprus. What does it mean? Cyprus means as nearly as possible to the testator or donor's intentions when these cannot be precisely followed. What is the explanation of the doctrine? Where there is a gift or trust for a charity which be substantially but not literally fulfilled, it will be effectuated by moulding it so that as nearly as practicable the intention of the benefactor may be carried out. Recommendation by Law Commission. On the recommendation of the Law Commission, the doctrine of Cyprus has been applied to suits under section 92 of the code, subsection 3 to section 92 as inserted by the Code of Civil Procedure Amendment Act 1976. This is very much similar to the English Charities Act 1960. And as I have been telling right from the beginning of my classes, this class is dedicated to a charitable organization by name ABC Trust. As you are fond of this class, may I request to please make a small donation of rupees 59 to the ABC Trust, where the UPI number is 994939 8998. Your contribution of 59 rupees will be utilized for enriching the nutrients of school-going children and their education as well. At the end of this class, a QR code is going to be displayed, which will be very easy for you to scan and make the donation. In addition to this, I would also like to make a request that please subscribe to my channel, because your subscriptions are going to be the blessings and encouragement or encouraging for me to do more classes in the future. Thank you very much for watching my class, and namaste.